some other reason I can't say the PowerPoint. Okay, so for those of you not practicing in case lines, I know we have people from all over the country. What you see on there is a list. Sorry, it's an app, and it is utilized in the Gauteng province. Now, this is an app. Every time you're going to issue a matter, you're going to also upload it. They have court online, and case lines forms part of court online. Now, every case is also uploaded on here, and if you then want to view the case, you look at it on here, and every person who is involved in the case. So the plaintiff's attorney would open, or applicant's attorney would upload it, and then when there's a return of service and he or she sees who is the opponent, they will then invite the opponent, will also have access to the case, and then they will invite, if they have counsels, they will invite the counsel. So everybody who are invited and who have access to that specific case, anytime somebody uploads anything, they all will get a beep email, and then they can go and see, yes, there's something has been uploaded. It's a normal app. You can download it on your phone. You can download it on your device, internet. So yeah, that you get notifications if stuff is uploaded. And if you look at the case list, why I'm showing you this, because I wanted to show you that case lines automatically paginate the files, right? If we now look at, okay, there's a request for further particulars of trial, which I talked to you about yesterday. If you now look at it, you will see here in the corner, case lines have numbers, and you will see there's numbers in red. 015.1. Case lines have all those numbers. And this is basically the numbers that we are currently using at the trials. But despite that, the court still wants you to comply by drafting an index. And now the index numbers and that won't be the same. You can see here's an index. The index won't be the same because the index is start from number 1 on case lines, whereas when you number, your number 1 would be your summons, like it is with us, with some index to the pleadings. Do you see? They still want you to comply with this rule, although what we use now in courts are this rules, or this. Okay, so for those of you who are not in Gauteng, since 2019, the last term in 2019, the Department of Justice decided to buy this program from England. And then they did a pilot in Gauteng. They decided that they're going to do a pilot in Gauteng to see, because we want to work in a paperless society. Now, we suppose we go to court without files and stuff, and everybody has a laptop, the judge, all the different parties. And if you present, you want to, if you're in court and you're on this specific page and you now want to take other people to a different page, there's certain things you can just direct others to the page, and then you put in a number, and then everybody then will be directed to that page when you refer this to somebody, and everybody can work on. You can even, when you work on a file, I don't know if you can see, you can make notes on the one side, your own notes, like there says bail evidence. The court can communicate with you also in that file. So yeah, you can make the notes that you make, you can make it private notes, or you can make it notes that's widely published, that everybody who's on the app can see. So yeah. Then that was in 2019. They started with a pilot, and then they were going to bring it into all the courts in South Africa. But we know what happened beginning 2020. We had lockdown, we had COVID. So and that is one of the reasons why in Gauteng courts could still go on and courts could happen online, because having the files was not a problem for the parties, because the attorneys had, everything was uploaded. We already had this going on, and we already all had training and knew how it worked before lockdown. So when lockdown happened, it was just very convenient for us to have the virtual courts and the online courts. That is why some of the matters in Gauteng still today are held virtually. because the file's easier, and in Gauteng, if you do not upload it, you won't get allocated. So it's a requirement there. Okay. Yeah, I still can't share my for some or other reason I still can't share. What's this? No, I still can't share the, I don't know why. Let's see. Right, okay, so that is with the pagination. Also in the practice directions, just for your information, you know that you have, if the file is a bulky file and there's a lot of documents in it, there's rules in the practice notes with regards to how many must be in each bundle. Then you will have different bundles, and each bundle will have an index. So it will be bundle 1, and then it will have an index. And the rule is that it mustn't be more than 100 pages in a bundle, and it must be in a file that when you open a page, it remains open. So you can't just have it bulky and then staple it, so that people must hold their hand there if they open it, so that it don't fall back. But that was when that is still for where the court still use the paper. Okay, it's now different in Gauteng. They don't use the paper, they use the online. So yeah. Right. The next aspect that I want to talk to you about is settlement. Now, we have addressed settlement. Can you hear me? Am I online? Am I online?
Yes, advocate. We do hear you.
Okay, sorry.
Advocate.
Yeah.
Sorry, I just panicked for a moment because I can't see anything. Yes. Okay. Right. So settlement, you get two kinds of settlement. Now, Rule 34 of the Uniform Rule. Thank you. Rule 34 of the Uniform Rule deal with settlements. You get two kinds of settlements. You get a settlement, an unconditional settlement. What that basically is that you say, look, you're the defendant. I am liable. You admit liability, and then you want to settle the matter. You can settle part of the matter, and then you just adjudicate on the part that is not settled, or you can settle the whole matter. That is the first kind of settlement. And then there's the other settlement, and that settlement is the without prejudice settlement. Now, in this instance, in the without prejudice settlement, you do not admit liability. You're settling it for the purpose of keeping it out of court. You've weighed the pros and cons, and you think, okay, they may succeed with so much improving that the evidence is against me, but you never admit liability. That is a without prejudice settlement. Now, an offer to settlement must be sent to the opponent. It usually is done in writing, but those of you in practice, you would know that many of the matters settle on the steps of the court. That means on the day that it is set down for trial, then parties settle the matter. They say that it settles on the steps of the court. Judges tries to avoid this, because you know a judge has already been appointed, and then the matter settles on that day, and that judge then sits and has nothing for that day to do. Maybe he has something, but some other matter could have been heard. But there's nothing wrong. The matter can settle anytime before judgment is being handed down. The parties can agree to settle. But now when you make an offer to settle to your opponent, right? You make the offer to settle to your opponent, and then your opponent must consider the settlement offer and let you know within 15 days that he's going to accept it or he rejects it, and it comes with a counter offer. Then that is a new offer. And if he doesn't, say for example, I want to explain something to you. Say for example, the claim is for R1 million, right? You are for the defendant, and you say without prejudice you want to make an offer of 750,000 rand, right? The plaintiff says, no, I reject your offer. I don't want to settle for that amount of money. Say, for example, the plaintiff wants more. The plaintiff says, I'll go away for 900. You say, no, that is too much. 750 is my offer. Let's then go to court. Now you go to court, you run the trial. The plaintiff is successful, and the plaintiff proves damages, but the damages is only 700,000 that the plaintiff proves. Because remember, irrespective of what you claim, however many millions you claim, it doesn't mean that is what you're going to get. You have to prove your damages. So at the end of the day, in this scenario that I'm now sketching, the plaintiff has proven damages of 700,000. Now, a without prejudice offer should never be brought to the attention of the judge during the trial. You never get up and say, but I wanted to give them 750 and they just wasting time, because we could have all now been gone and they're wasting the court's time and they're wasting the client's money. You can't bring that up and say those kinds of things. Only in the case where there was an offer of settlement on the table, which they have rejected, and they prove less damages than what was on the table, then you bring it to the judge after he hands down judgment. Obviously, after he hands down judgment, so now you know what the judge has found. You then bring it to the judge's attention that there was an offer of 750, which they rejected. And in that case, the judge has the discretion, and in all likelihood would use that discretion and not allow them their costs. Remember, costs follow the cause. The successful litigant is always entitled to his costs. In that case, the judge will say, no, but you had a reasonable offer on the table. You couldn't prove more than that offer, so you're not entitled to your costs. You wasted time now. But that is only in that scenario. So that is why they say when you make a reasonable offer, so when you make an offer, you don't make ridiculous offers. You look at all the evidence and you look at the case law and you see, okay, this is where we're going. You make an offer so that your opponent would really consider it, and he's on risk because he knows that if he doesn't prove more than that, and if there's a chance that he may not prove more than that, if his evidence is a bit iffy, he will accept that offer. So when you do, as a defendant, when you make an offer, you put them at risk. Okay, so just remember that. And you don't tell the judge without prejudice offer. You don't tell the judge. You can only tell the judge once the plaintiff doesn't prove more damages than what your offer was. Okay. Are there any questions on settlements before I move on? Oh, is there a hand up? Yes, can you may proceed.
Okay, thanks, ma'am. In terms of you having to offer, does it not in one way or the other actually admitting liability?
Okay, there's two kinds. There's the one that you admit liability and you say, okay, I'll pay. Then there's the other one, it's without prejudice. It is so that the matter can go away. Because sometimes litigation costs more than what the claim is worth. I'm sure you have seen that. So if you weigh up and you say, okay, I'm going to spend like 200,000, I'm going to spend like $1 million on litigation because I have senior counsel and I have all these experts in that. Let me offer them less than that and avoid that so that we all go away. So it's a without prejudice offer. That's why you don't tell the court about it. The court mustn't know about it. That is now when you don't want to admit liability. It in no ways means that you are admitting liability. It is just so to keep it out of court. You're not saying, I agree that I am liable. I agree that you're making an offer so that the matter can go away.
Okay, thank you, ma'am.
Sure. And just remember, everyone, if you make with settlements, it is very important that you do know your client in the whole procedure, because you are acting on behalf of your client and you can't undersettle. Your client must be happy with the settlement. So whatever offer you get, you have to take it to your client, and then you must explain to your client whether it is a good offer, and whether what the client will usually ask, what do you think? And you can explain the law and say, this is the risk and this and that. Your client might say, but I want more, and you can explain everything to him. And if the client says yes, the client must agree that you take a settlement offer, or that you make a settlement offer for that. for that matter. You can't also, on behalf of the defendant as the attorney, make an offer and you don't have instruction from your client to make that offer. So know your clients in all of this. I've seen many cases where clients come back to court with the new attorneys and then they sue the erstwhile attorneys for professional negligence for undersettling their matters, because then they heard from somebody that another matter, similar matter, was settled for more and this was undersettled. So get your clients confirmation that he accepts it and that you've explained it to him. Get it in writing, protect yourself, but do get instructions from your clients if you are going to settle matters. Okay, there's another hand up. Ntanganesi. Ntanganesi. Sorry, I'm saying it wrong. Marandi. Ntanganetseni. Marandi. Your hand is up, but you are muted. Do you still have a question or may I proceed?
No, ma'am, it's an error.
Okay. Jovan, my screen is not being shared for some other reason. I can't share that screen. I can share other screens, but that one doesn't appear here for me to, and I don't know why. I am so sorry about that. Right. Can I move on? The next, okay. The next rule that I'm going to deal with is Rule 34, capital A. That is now interim payments. Now, I don't know if you are aware of it, but when you have a claim against a defendant and the defendant admits liability in writing, or the court makes an order that the defendant is liable, provided that the defendant is able to pay, provided that the defendant, and if the defendant is an insurance company, like the Road Accident Fund Insurance, or like the MEC for health, for medical negligence, in those kinds of cases. Remember, we talked yesterday about Rule 33, the separation of the issues. And sometimes people agreed to first hear the merits. And then I said, then you go back in the queue and now you must wait for a court date to hear the quantum. Now, it's a long period of time where the plaintiff is not going to have any income sometimes. Now, if there was a claim for damages for personal injuries, then anytime after the plaintiff has either admitted liability or the court has made an order to say that the plaintiff is, the defendant is liable, and before the quantum is heard, the plaintiff can then serve a notice, bring an application for an interim payment. That is now a payment in the meanwhile, right? So the defendant can make an interim payment, and it's only and with regards to two specific heads of damages: medical costs that was incurred, and then loss of income. Say, for example, the plaintiff is the breadwinner of the family. Because of the injury sustained, cannot now work anymore. The whole family is suffering. The children can't go to school, all of that. So you can, and now the merits has been settled. You know that the defendant is liable. The defendant is an insurance company, is the Road Accident Fund, or it is the MEC or other insurance company. Then you can then ask the court to make an order for an interim payment, not for the whole amount, but for a substantial amount of money that can cover that for until you hear the matter is being heard. The final matter is then being heard in court. Sorry, the quantum is being heard. In this application, the court must be satisfied that the defendant has in writing admitted liability or that the judgment has been obtained. The defendant is must also be covered by insurance or has the means to enable them to pay. And it can be a substantial amount of interim payment. I've seen recently a matter where the court make an interim payment of 5 million. The quantum has not been heard yet, but the defendant, they've settled the liability aspect, and the claim is in excess of 30 million, and the court made an offer, made an interim order that 5 million must be paid in the meanwhile. So just remember that, yeah, if your opponent, if it's not by court order, the opponent must in writing have admitted liability. Okay, so that is 34. Do I have any questions? 34A, that's 34A. No questions. We move on. Right. The next aspect that my slides deal with is the attorney's duties during the trial. Now, the attorneys have certain duties during the trial. If you look at your manual, you will see that they say that you must know the case as if you are going to present it. Remember, we're doing high court practice with, and usually, or traditionally, it was only advocates who appeared and the attorneys was with the advocates. That is not the case anymore. But if you are going to be an instructing attorney who's going to appear with counsel, then you must also know the matter. You must prepare your arguments in advance, they say. And yeah, you must, they say something about wise arguments and not about being wise and not always trying to be the clever guy. Yeah, they mentioned something. I just want to get there. Anyways, so what happens is with a referral system where attorneys instructs counsel. Attorneys is supposed to always get the instructions from the client and tell counsel what the client says. So this is what your notes say on page 148. It says that the golden rule in any court proceeding is that the attorney must be fully prepared. So-called brilliant questions or clever arguments are never discovered or formulated in court. They are the result of preparation, and more preparation before the trial. Always understand the difference between a clever argument and a wise argument. In broad terms, an attorney would conduct his client's case and put forward clever arguments. The judge, however, will dispense with justice on the basis of a wise argument, and it behoves a legal practitioner to include wise argument in his presentation of the case to the court. Okay, so basically it says that you must be careful. I don't know if you do know the difference between being clever and being wise. Anyone want to take a go at that? Or should I just tell you what Google told me? Clever, Google says, is knowing that that tomato is a fruit. That's being clever. Wise is knowing that you don't put tomato in a fruit salad. So the difference between being clever and being wise, you can know stuff, but how are you going to implement it and how are you going to prepare? Preparation is very important. So just remember that when you present your case, and even if you are there in an instructing capacity in the High Court, know that you must know everything about the case, because they're going to ask one question answers from you. If counsel gets stuck and he wants to know something, he usually asks the attorney. Okay.
Sorry, advocate. What
yes.
page you said?
Did I read now? 148.
148. Thank you.
148. Okay. The next thing that we're dealing with, the next item that we're dealing with, or rule that we're dealing with rather, it's rule 47. Security for costs. Right? Now, security for costs is basically what it says. If you want your opponent, it would usually be the defendant, although the rule says a party. The rule doesn't specify that it is only a defendant. The rule says a party. But if you desire to demand security for cost from another, you shall, as soon as practical after the commencement of the proceeding, deliver a notice and set forth the grounds in terms of which you're claiming this cost. Now, what this means is that you are the defendant, right? The plaintiff serves a summons on you. If you think that you have a valid defense, this is a nonsense claim. The plaintiff is just wasting my time. I'm going to waste my time. I'm going to waste my money. Then you can ask that you can serve this notice demanding security for the costs, because remember, successful litigant is entitled to the costs, and you want to know that the cost is going to be available at the end when you successfully defend this action. So that is what we mean by security for costs, right? In certain instances, you must in certain instances it's required where the plaintiff is a peregrinus who sues you, and you the defendant, and you know the plaintiff doesn't have any assets here, you can demand security for cost. Also, where the plaintiff is a company or a CC who might be liquidated, and by the time the litigation is finished, won't have the cost. So then you serve this notice on them, and they must then, you will say what the amount of cost is. If they don't agree with the amount, the registrar can determine what would be a fair amount for the costs. And if they don't want to give the cost, and they have a very good reason, because it's not only for a peregrinus or for a company or a CISU who may liquidate, it can also be somebody that takes you to court for nonsense. You know, you get those kinds of people. They litigate in person and they take everybody to court. So if you get a matter like that, you are for the defendant. Before you defend, you can demand security for costs. Cost is usually given, the security for the cost is usually given by way of anything of value. Movables, something that has value, and it's usually given to the registrar of the court until the end of the matter. Okay. There's a reported case where a person offered a truckload of mangoes as security for cost, and the court says no. The thing that you are given as security must have value at the end of the matter, and the mangoes won't be valuable then. So it must be something of value. It can be anything that is movable, and you serve this notice. Now, if you can go to court and the court won't, remember, we all have the right to access to justice. If you have a good case, if you have a solid case and you are for the plaintiff, and you serve summons on the defendant, and the defendant now knocks you with this notice for security for costs. If you have a good case, you can go to court and set the matter down as to why you should not pay security for costs, because you have a prima facie case that the defendant must answer. The court won't close its doors to a person who has a case. So you can go and challenge that. The rule doesn't say when the security for costs must be paid by the defendant. It only says it must be paid within a reasonable time. So in a reasonable time can be anything. Then the plaintiff can then, once the The defendant, if it's not paid within a reasonable time, the defendant can set the matter down and then have the case struck, dismissed, based on the fact that there was no security. But as I say, if you do have a case, and you have a prima facie case, but you may be indigent or you can't afford to pay, then the court won't. The court will say you don't have to pay security and you can litigate. Are there any questions on that? That is Rule 47. Now, there is a Rule 47 capital A that says that if a person is represented by the legal aid by a justice,
Advocates, I can't hear you anymore.
You're not the only one. The advocate is gone.
hello, can you hear me? For some other reason, I lost connection. I don't know
Yes,
what's
we hear
happening.
you now.
Can you hear me?
Yes, we do.
Yeah.
Okay.
The way that is
I've
bad.
asked that the legal aid, and when people are represented by the legal aid, then you can't serve them with that notice. Okay, this is probably the case why. Okay. Are there
Advocate, your line is breaking.
questions?
Hello. Hello.
Hello.
Hello, advocate.
Hello. Can you all hear me?
Yes, we can.
See the
Now we
messages,
can.
yeah. Okay, thank you very much. Yes, there's no questions on that. Are there any questions?
Just for interest.
Yes.
Yes. In
Somebody says no. Yes. Sir, do you have a question? Do you have a question? Okay, I'm going to continue. I can't hear your question for some other reason. I don't know if you're asking it and I can't just hear it, or are you not asking a question?
hello.
Yes, I can hear you.
Yes, thanks. Now I was saying I just wanted to ask just a question for that in criminal, then you will have a criminal record. Then in civil, you will have a what, or civil matters does not affect your status.
You say a criminal record, if you have a criminal record?
So I'm saying in criminal, you will have a criminal record.
Yes.
Then civil, then your status is not maybe affected in any way.
Do you mean can people with a criminal record still sue? Yes, no, you have locus standi. If you are a fugitive from the law, then you can't institute. That is if you're running away. But if you're facing your accusers and you faced your accusers and whatever, you've got locus standi. That's not a bar to locus standi.
Advocate, my understanding
Okay,
of
what
the
does
question,
ITC mean? Yeah.
my understanding of the question is that, do we have a register like we do have for criminal records in civil matters?
Yeah, that's exactly my question. Thanks, my brother.
Are
Thank
you
you very much.
talking?
Thank you.
You say, do we have a register for civil matters as we have if you have judgments against your name?
Yes.
Okay, somebody's answered ITC, but that's only for debt. It wouldn't be for anything else, like for a divorce. There's a divorce judgment against you, not like that. But for debt, you get reported on ITC, but it only remains on your name for 5 years.
Oh, okay, no.
But you
Never.
can have it removed if you have the judgment rescinded. And you can have a judgment rescinded if the judgment creditor agrees to have it rescinded. So if it was for debt and you have satisfied, you've paid all the debt up, you can ask them for a letter to say that it's paid up. Then you can apply for the rescission of the judgment in the match court and in the high court. And then the judgment will be off from your name.
No, thank you very much, Advocate. You have answered me. Understood. Thank you.
Okay, sure. Right. I'm sorry about the slides. Right. Okay. Then the conduct of the trial. With regards to the conduct of the trial, I think with regards to the conduct of the trial, when you start the matter, you usually would start with an opening statement. The court might ask whoever, remember I said that the onus, who has the onus to prove, and that person usually would have the duty to begin. Okay, so whoever starts will then make an opening statement. And the opening statement, it has the same value as an argument. During your opening statement, you give an overview of the case to the judge. You're basically going to tell the judge what the matter is about. You will say, this is a delictual claim. It's have I been lost again?
No, we're
Now
hearing
we still hear you.
Can hear you.
Oh, because I just saw a note. Sorry, I saw a message that somebody says they lost me. Okay, so in the opening statement, you would then give an overview of the matter to the judge. So you will say this is a delictual claim. It is for a personal injury suffered in a motor vehicle accident. And then you will say, to prove that the defendant was negligent, or the insured driver of the defendant was negligent, I'm going to call the plaintiff, and he's coming to testify that on this day he was driving and that one drove into him. You just give a short overview, and then whatever other witnesses you are going to call, you tell the judge. That is an opening statement. So it has the same value as an argument, and it's just to identify the issues so that the judge, when it sits and listens to the evidence, he knows where you are going. He already has an outline of what's going to happen before him, so that he can follow the evidence and knows what's going on. Okay, so that is the opening address. Then during the trial, you would then if it's your witness, if you calling the witness, then you must put a prima facie case on a record through your own witness. That's why your witness is coming to testify. So in examination in chief, your witness must give evidence of what happened. Now listen carefully when I say that. Your witness must give evidence. The rule in examination in chief is that you are not allowed to ask leading questions. Now, what is a leading question? A leading question is a question that suggests an answer. It would be the legal practitioner telling the story and then the witness just saying yes or no. And that is not evidenced by the witness. That is evidenced by the lawyer because it's leading questions, and the court cannot consider that because the lawyer is not a witness. The lawyer is not under oath. Okay, so you won't ask leading questions. You would ask open-ended questions that will then allow the witness to tell the court the story in his or her own words. So when you prepare your witness, you would go there. Now, I don't know if you are aware of the rule of a few tricks that we use to adhere to this no leading questions during examination in chief. Some of you might have heard about the husband and the 5 wives. When a question starts with any of those, how, where, what, when, who, and why, that if a question starts with any of those, then you know it's an open-ended question and the witness must then explain. That is the one tip that I can give you for not asking leading question and open-ended question. Why did it happen? What happened? Who was there? You know, that kind of thing. The other thing that I can also just give you a tip on is when you ask a question, and sometimes your witness might go off track, as people are, we are all fallible, go off track and lose track, how to bring the witness back, because you can't tell the witness, you must now just do this and that. It's now the witness and you must just lead the witness to give the correct evidence. So put the correct evidence on a record. But it is a system that they call piggybacking. Piggybacking is the witness answers a question, and so that the witness don't digress, you use part of the witness's answer, last answer, in the next question. So you ask the witness, where were you on that night? And the witness will say, I was at home watching TV. Then you can maybe say, what were you watching on TV? Then the witness can say, I was watching a movie. And then you can say, then what happened? And then the witness will say, then I heard a shot. And then you say, you heard a shot. And then, do you see what I mean by keeping the witness on track and piggybacking on the previous question? So that is just a few tips on examination in chief. Remember, no leading questions are allowed. Cross-examination, again, you can ask leading questions because this is you cross-examining your opponent's witness. Now, your opponent's witness, you want to attack the credibility. You want to choose to test the veracity of whatever they said, and also the reliability of their witnesses. Right? That is what you do in cross-examination. And remember, during cross-examination, you attack the credibility and the reliability of the witnesses. The other thing that you must not forget is you always put your version to the witness that you are cross-examining. You will say, but I have a witness who's coming to say whatever your witness is coming to say, or if your witness has already testified, but we had a witness who testified X, Y, and Z. What is your comment on that? You always put the version that is contrary to what that witness has said, so that that witness can comment on it. Okay, so you try and break down the witness credibility during cross-examination and the reliability and the truth of that. You test the truth of it, right? And then re-examination, it's not always necessary to re-examine. You have to then call that shot as you are in court. If your witness was strong during cross-examination and there's nothing that you have to clear up, don't re-examine. If your witness was so bad you can't salvage anything, don't re-examine. Re-examination is limited to issues raised in cross-examination, and sometimes your witness didn't explain himself correctly, and you know that if you ask your witness a certain question during re-examination, it will clear up misunderstandings. The rule for re-examination is the same as the rule for examination in chief. No leading questions is allowed. But you can clear up misunderstandings, and if it is possible to restore the credibility and the reliability of your own witness by asking a few questions and bringing the witness back on track, you do re-examine. But if the damage is too bad, then rather don't. But I mean, you make that call. So that's basically during the trial, and then you have at the end of the plaintiff's case, when the plaintiff closes their case and the plaintiff did not present a prima facie case, you can ask for absolution from the instance, or you can just close your case also and argue for judgment against the plaintiff without leading evidence, or you call your witnesses if you're for the defendant, and then sometimes the court would want you to do argument from the bar, like in court, oral argument, or the court might say, I want written heads of argument, which the high courts usually do. And then you give written heads of arguments whenever agreed between the parties, where you then, in the heads of argument, you sum up. What you do is you sum up the evidence, your evidence, and then you tell the court, what is the substance of your case. You identify then the weaknesses in your opponent's case, and you tell the court what law should be applied and why the court should then give you the relief that you are looking for. That's in a nutshell, that is the conduct of the trial. Okay. Any questions on that?
Yes, Advocate.
Yeah, go ahead.
Can I please ask, what's the point of heads of argument?
The point
of submitting heads of argument when you made your submissions already?
Sorry, there's a. You said, what is the point of making heads of argument?
Yes, when you've made your submissions already.
When would you have made your submissions?
I thought you said you file your heads after you've made your oral submissions.
No, I did not say that. I said the court may say they want it in writing, or they may say you must argue. It's one of the two. It's not both. Okay.
Can you switch down your volume when you're talking? So there isn't an echo.
Is it better now?
Yes.
Okay, yes. I'm sorry that the person who asked the previous question before you, sir, I misunderstood. I said you can either do the argument orally immediately at the close of the case. Sometimes the court will go that route, but in most cases in the High Court they will say no. I want written heads of argument. So it's not that you do both. You either do the one or the other, because both are arguments at the end of the case. Is that clear? Yeah.
Yes, I understand.
Okay.
I think I misunderstood you. Yes.
Yeah. Okay. Any other questions?
Yes, I have one question I would like to ask.
Yes.
Yes. So here, I want to just please refresh my memory, because I'm not too sure how we discussed it the last time. When we are drafting our pleadings, we do not include any law. We just only argue the facts or what happened.
Yes. Yes. On the pleadings. Yes.
We don't maybe like say according to section what we don't add that in our pleadings.
Just give me more information. I've
Okay,
seen the
like-
people refer to acts in the pleadings, but you argue the facts. So if there's a fact that there's an act, yes, I said you don't argue evidence. I
Oh,
didn't say you don't argue the law. I said, sorry, in the pleadings, you don't include evidence. You include facts. You're going to lead evidence at the trial. That is what I said.
oh, okay. Okay, thank you. So we can
Okay.
include a section of an
Yes,
act.
people do that. People do include sections because that is the facts.
Because
Part
it's
of the
something we
fact.
can also rely on later on in the case. It doesn't matter even if we add it during the pleadings.
But you don't. People usually do not, as a rule, they steer away from it because we only want the facts. When we do the heads of argument or when we make oral submissions in court, we will then point out what law is applicable to those specific facts.
So it's better not to include, or how would you
Sometimes
advise?
you can't. Sometimes you can't avoid including it. It depends. Sometimes you have to say, but in the Maintenance Act, it says that this person must give and therefore he's responsible. You see what I'm saying?
Okay, I see.
Sometimes you can't avoid. Okay, somebody's hearing an echo. Are you still hearing an echo? No. Okay. Sometimes you can't avoid adding acts and laws.
Okay, thank you.
Okay. Am I still echoing? You say yes. I thought I'd dealt with that. Did I not deal with it?
You did. Someone else's mic is still on. The same person who's causing the echo.
Oh, okay. Right. Can you can everybody hear me well? Because I'm now getting confused.
Yes, we hear you.
Okay.
We hear you.
Okay, no, fine. Right. Let's then move on from the trial. We've now ended. Thank you. We've now ended that. Just remember that the burden of proof never shifts. It's determined at the outset who must prove, and the duty to begin rests on the party who owns that. Remember, right at the beginning when we started with this, I said that we're going to deal with provisional sentence summons later. So this is now where we're going to deal with provisional sentence summons, because I've dealt now with simple summons and with combined summons. So now I'm going to deal with provisional sentence summons, right? That is Form 3 to the Uniform Rules, Form 3, and you use this procedure if the claim is based on a liquid document. And what is very important to remember is you must be in possession of the original liquid document if you want to use the provisional sentence summons procedure. Now, this is a unique hybrid speedy procedure whereby the creditor in possession of a liquid document may obtain speedy judgment for the amount payable on the face of the liquid document. It's a quick way to get a judgment if you have a liquid document on which the creditor, on which the debtor would say, I owe the creditor that amount of money. Right. Now, in order for you then to succeed with this, I said you must have the original liquid document, but the document must also comply with the requirements of a liquid document. So what is a liquid document? A liquid document is a document that under proper construction, evidenced by its terms and without resort to extrinsic evidence, is an unconditional acknowledgement of indebtedness in an ascertained amount of money. Sorry, somebody said something about echo is usually caused by simultaneously joining the meeting. It's an unconditional acknowledgement of indebtedness in an ascertained amount of money, the payment of which is due to the creditor. So an example of a liquid document would be a check, an acknowledgement of debt, a bond, and your notes will, your manual gives you a few other examples as well. But it must meet the requirements. The amount of money that is owed must be certain, and there must be it must be in writing, and it is an acknowledgement of indebtedness. So the signature of the person who owes it must be on there, right? And if you have that original document and the person owes you on that document, you can go to court using this speedy. And they say it's hybrid because you start off with the summons, but then the defendant files an affidavit. Okay, so where once you've utilized this, the plaintiff utilizing this, there is not a lot. Yes, is there a question? Is there a question? Oh, the plaintiff utilizing this, there's not a lot that he has to do. All he has to have is he has to have the liquid document. Right? And from the liquid document, you can see that the defendant has acknowledged in writing that he owes the plaintiff the money. The only thing that the defendant can really then on the document challenge would be the authenticity of the signature. Say, he can maybe say that the signature is not his, or that the agent who signed the signature, if it is a juristic person, didn't have the authority. So that is what the plaintiff has to prove: the authenticity of the signature and the authority of the agent, and that is all that the plaintiff has to prove. The defendant, on the other hand, if he wants to resist a provisional sentence summons, yeah, he can raise any of the normal common law defenses that you have in contract, which would be undue influence, misrepresentation, duress, fraudulent obtained. Those are all the defenses that the defendant can raise, right? Now, the defendant then files an opposing affidavit, and then the plaintiff files a replying affidavit, and then the matter is enrolled and it is heard, right? Now, if you look at the name, it says provisional sentence summons. Provisional, look at that, provisional, right? So this is now the vehicle used by the plaintiff to get a quick result. He has the liquid document, he has the original. The defendant cannot come up with whatever defenses, right? If the court grants provisional sentence summons, if it's granted, the defendant can still, the matter is still not final because it's provisional. The defendant can still enter into the main case, means he can still then plea, and then they do the whole thing, provided that the defendant, within 2 months after the court has handed down the provisional sentence judgment, that he pays the amount plus the costs. Then the defendant can participate. The plaintiff must then give, there's some noise at the background. The plaintiff must then give security that money is going to be available at the end of the trial, and then the defendant can enter into it and then participate. Now the trick here, okay, somebody, can you just, I'm going to try, and I doubt that I will be able to, but I'll try and mute somebody. Can everybody just mute, please?
Maruping.
Can you mute? Sir, can you mute your? Okay, I'm just going to continue. It's Maruping. Bonakwana. Disable mic. Okay, they have done it. Right. Where was I? Provisional sentence summons. Okay, so if the defendant within now the rule says, it's rule 8, by the way. The rule says that the defendant has 2 months in which to satisfy the debt plus the costs. If he pays within that 2 months, he demands security that the money is going to be available, and the cost is going to be available at the end of the trial, then he can participate, and then they go through the whole trial as you would. If the defendant does not pay within that 2 months, then the provisional sentence judgment becomes a final judgment. Okay, so you can see why a plaintiff would use that. So if provisional sentence is refused, the defendant must then file a plea, and then the rules of pleading and the further conduct of the trial apply. If it grants it, the defendant must pay the amount, right? In order for him to be able to file a plea. Now, the advantages of provisional sentence for the plaintiff, it is actually more advantageous for the plaintiff, because all the plaintiff needs in this regard is the liquid document and proving that the signature is the signature of the defendant. And the court in provisional sentence summons proceedings does not allow oral evidence, but only if the defendant challenges the authenticity of the signature on the liquid document. Will the court allow oral evidence only on that aspect? So the defendant files a affidavit, the plaintiff files a replying affidavit, and the matter is heard, and the court will then decide whether the defendant has a defense. If the court finds that he doesn't, then the court will grant the provisional sentence. Within 2 months, he must satisfy that in order for him to participate further. So usually, if a claim is for a large sum of money, effectively, provisional sentence is then a final order, because the defendant may be unable to make payment to the plaintiff or to enter into the principal case. I mean, it just goes without saying that the defendant is the party who's at the disadvantage here, because he can't really oppose it if he doesn't have money. So there was a challenge in the Constitutional Court. There's the case, and it is in your notes, of Twee Jonge Gezellen, right, versus Landbank. Now, in terms of what happened in that case is the following. Landbank loaned money. I forget the amount of money, but it was millions, to this Twee Jonge Gezellen. It's a farm, a wine farm in Tilbach district in the Western Cape. So Landbank loaned money to them, and they were in default of repaying it, and Landbank took them to court. But prior to the matter coming to court, they entered into an agreement. Twee Jonge Gezellen then signed an acknowledgement of debt, in terms of which they're going to pay every month. Then they were in default again after signing the acknowledgement of debt, and then the Landbank went to court with that acknowledgement of debt as the liquid document. Now, Twee Jonge Gezellen wanted to defend, but they couldn't defend because they didn't have the amount to pay. Because remember, the rule says in order for you to participate within 2 months of the judgment being handed down, you must pay. So they took it right up until the Constitutional Court, and they said that Rule 8 of the Uniform Rules is unconstitutional, because it actually denies them access to justice. They want to defend, but just because they can't pay, they can't defend. The Constitutional Court then did not declare Rule 8 to be unconstitutional, but they said that the courts in each and every matter where provisional sentence summons is used must look at it on a case-by-case basis. And if the defendant in his affidavit demonstrates that he cannot pay because he doesn't have the money, and that he does have he wants to defend it, but he doesn't have the money, then the court should not grant provisional sentence, and the court should give him an opportunity then to defend it without having to pay it. So basically, the court said, look at it on a case-by-case basis, and if it appears to the court hearing the matter that the defendant really has money, the means to pay, because remember, it's you pay and then you demand security, and at the end of the day, if you defend successfully, you get your money back. But the court said if the defendant has the means to pay, but is just unwilling or it's just uncomfortable or inconvenient for him to pay, then the court must grant provisional sentence summons. But if it is somebody who really can't pay, who's an indigent person, the court shouldn't close the doors, and that person should be allowed to defend without paying, even if the liquid document is a liquid document and the person have acknowledged the indebtedness, can still be allowed to defend. Okay, so that's, do I have any questions on provisional sentence summons?
Yes, advocate.
Sure.
I just want to find out what happens to the money that you pay and then you proceed to defend the matter. What happens to that money? Is it a form of a security or is just paying the debt?
Now you pay the money to the plaintiff if provisional sentence is granted, and then you at the same time you demand security that that money and the cost is going to be available at the end. So not in terms of the money, but some sort of security that the money is going to be available. That is what you do. So the plaintiff must also give security that the money is going to be available should they successfully defend the action.
So in essence, they cannot dispose of the money until the end of
they can dispose of the money. They can give security. Like I say, security does not necessarily mean money. It means anything of value that they can give as security for that amount of money.
Equivalent to that money that you paid, because you might still be successful at the end of the matter.
Yeah, but it doesn't mean they can't use the money. They must just give security that they have that amount readily available, or they have jewelry to that value, or they have whatever properties that they have that they give as security. Should you successfully defend, we can satisfy the debt if we need to.
I perfectly understand.
Okay. Any other questions?
So, advocate,
yes,
if I'm understanding you correctly, you are saying that a provisional sentence summons is basically a judgment.
If you can't pay, yes. That is why it went up to the Constitutional Court, because all the plaintiff must have is a liquid document, and he can be successful to get a judgment. And if you're poor and you can't pay, if it's millions of rand and you don't have access to that money to pay, you can't participate. And that is where the Constitutional Court said, look at it on a case-by-case basis.
Oh, that makes sense. Okay, no, thank you very much. Now I get it.
Okay, sure. Yep. Anything else?
With
yes.
kind of application, when you make application, the judge will find in your favor based on the evidence in front of the court.
All the evidence that you have to have as a plaintiff is the liquid document.
Okay. Then the judge will grant you judgment to say that the defendant must pay you that money pending the finalization of that case.
The judge says because of the liquid document, say it's in writing, it's an unconditional acknowledgement of indebtedness to the plaintiff, you must pay that. The judge can make that judgment, yes. But you can still participate and still defend if you pay that money within 2 months of the judge having made that order. What was your question?
Yes, you are answering my question. My question was that based on the liquid document, which was attached to the provisional sentence provisional summon, so the judge will make a ruling or a judgment based on that to say that the defendant must pay that money.
Yes.
Oh, okay.
And then he must pay within 2 months. And if he doesn't pay within 2 months, then it essentially is a final judgment.
Oh, okay. So if the defendant paid that money, can the defendant still defend that?
Yes.
Oh, okay.
Yes.
Okay.
Then the plaintiff must give security that the money is going to be available if the defendant defends it. But yes, if he pays it within the 2 months, then they can still go on and conduct themselves as a normal trial. Yes.
Oh, okay. Okay. Thank you very much.
Yes. Thank you. Zukisani.
Yes, thank you, Advocate. I just wanted to ask, do we not already have default judgment in place for you know, when you have a liquid document? Why do we also need, is there a particular reason as to why we have provisional sentence as an option as well?
Where do we have default? Okay.
Okay.
I think let me just try and explain. Default judgment is when there is no notice of intention to defend or no plea by the defendant. It's not always by, but you can also use it. You can use the combined summons in each and every instance. You can use the combined summons in each and every instance. You could have used the combined summons also, but then you're going the long route. So default judgment is when there's no notice of intention to defend first, then you can go for default judgment. Or if there's no plea, then you can go for default judgment. That is when you go for default judgment. So this is something totally different to that.
Understood, thank you.
Advocate, can I ask you something?
Yes, what is it?
Can you pay under duress? Now, just this is an example, a scenario. You gave your creditor a check. You paid for the goods. Then you realized that there was something faulty in the goods, and you cancelled the check. Okay, so
yes,
he took you to court under this provisional judgment.
Yes.
You pay, but your argument is going to be that the goods were faulty, and that's the reason why you cancelled. But you pay upfront. Can you do that, or is that? Can you do that?
Okay, so then he would have a check that bounced, right? And he takes you to court on that. Use the provisional sentence summons. Exactly the scenario when you would use provisional sentence summons to get a quick judgment. Then you can explain to the judge what your defense would be as to why the check bounced. But if that is the judge will then decide whether he should allow you to be able to defend without paying the full amount, and demanding security from him.
Okay.
It's in the judge's discretion. Because obviously there would be a dispute. You're going to say one thing, and the plaintiff will probably say something else.
Yeah.
Are you talking about a specific thing that happened? What was the outcome?
No. I'm just thinking, you realize you pay, but you suddenly, COD delivery, and you open the parcel, you have to pay, you pay them with a check. You open the parcel, you find that instead of 2 shoes, there's 1 shoe. So
okay, I hear you.
Immediately cancel a check. Okay.
And then he takes you to court.
He takes the case up and says he sent you 2, etc., or whatever. Then I'm saying is, with the provisional sentence, do you have to pay up front, like you said?
No,
and then
only if the judge, you will explain in your affidavit that was a misrepresentation. That's why you cancelled the check. You will explain that in your affidavit. And then the judge will say, I don't grant provisional sentence summons because clearly you didn't deliver. And then you will be allowed to defend without having to pay. Then you can file your plea.
Okay, fine. Thank you.
Okay. Is there more hands? Are there more hands?
Yes,
Yes.
Advocate. Please, can this provisional sentence summons be also heard in the magistrate court?
Yes, they have the same procedure in the magistrate's court as well.
Thank you.
Because of the monetary jurisdiction. Remember,
Yes.
the magistrate's court, monetary jurisdiction for the district court, it is 200,000, and for the regional court, it is 400,000. So if the claim is for those monies, then you would institute it in the magistrate's court.
Excellent. Thank you.
Ma'am,
Okay,
can I
there's
ask
a question.
please?
Okay, yes. Who's that?
Is Joachim speaking?
Yes, Joachim.
I just want to find out if the judge hands down a provisional sentence and the defendant pays, obviously, but it goes to trial and the defendant is successful.
Yes.
Does he or she get refunded? They obviously get refunded. Is that the reason why the plaintiff has to provide security?
Yes, yes, that is why they have to give security in case the defendant is successful and must be given the money back. Yeah, then that security falls into place if you don't give the money back. Yes.
Okay, thank you.
Yes. John has a question. When AOD acknowledgement of debt was signed on 19 October 2019, by example, and you don't receive payment of the due debt, by when are you required to serve your provisional? A debt that prescribes within 3 years, John. So you would have to have issued the summons before the 19th of October 2022. Is it 2021? Yeah. So otherwise it has prescribed. Provided that the prescription has been interrupted, you acknowledge debt or in writing, or you have something that shows that the debt has not prescribed. But a debt prescribed within 3 years, and yeah, John, can you hear me? Okay. Any other questions on provisional sentence summons? Okay, so that would then be actions. Okay, that would then be actions. That would be actions. We now move on to applications. Remember, with applications, in the High Court, applications are dealt with in terms of Uniform Rule 6, right? And we've already discussed this. You're in your consultation and you have to decide whether you're going to use the action procedure or the application procedure, right? Now, before I start there, I just want to tell you there are two kinds of applications, and I'm going to use the word application and notice of motion interchangeably. Interchangeably because it is the same thing. So motion proceedings and application proceedings are the same thing. The parties, like we said before, are called applicant and respondent. Now you get an ex parte application. And you must have heard of an ex parte application. This is an application that involves only the applicant. There is no respondent. So this application you usually would just address to the registrar of the court. There is no respondent, so no notice is given to the respondent. You're not telling the respondent that you have so many days in which to file a notice of intention to oppose. You have so many days to file an answering affidavit, and you have to give an address within 15 kilometers. All of that is unnecessary because there is no respondent. There's no opponent. An example of an ex parte application is what you're going to do when you apply to court to be admitted as an advocate, sorry, as an attorney of the High Court of South Africa. So being admitted as it's an ex parte application, we don't expect anybody to be a respondent and to oppose our application. Yeah, it is. You make out your case, and you're there, and you ask to be admitted. Right. Then I just need to clarify something, because you would have also heard in your interaction with lawyers and with your law, being involved in law, that sometimes people say they bring an ex parte application, but that there is then in those cases a respondent. That is when they go to court and the respondent is not before court because there was not enough time for the respondent to be at court. So then they usually say they bring the application ex parte, the other party is not there. Okay, so in that case, the court would usually give a return day where the respondent is then afforded an opportunity to come to court and to say why the order should not be made final. Okay, that's usually with urgent applications where there's no time for the respondent to come to court on time and the matter is heard in his absence. Interim relief is given in his absence, but the return day, remember the audi alteram partem rule is very important. The return day where the court is then hearing the other side and then decide whether the order should be made final. Okay, and then people, the reason why I'm telling you this now is because then people would talk of they brought the application ex parte, but it's not an ex parte application in the sense that there's only one party. Like, for example, your admission as an attorney is going to be an ex parte application. A lot of other application for the appointment of a curator, that's an ex parte application for what is that? We did it, a substituted service, where you can't find the opponent and there must be personal service. That is also an ex parte application because there's no opponent. Okay. Is there a question?
No,
you can't hear me.
In some interlocutory applications.
Interlocutory application is not an ex parte application. An interlocutory application is an application that you bring while there's a main action or application pending in the court. When you are sorting outside issues, matters that are ancillary to the main action, then you bring an interlocutory application. For example, we did exceptions. Exceptions are heard as opposed motions. That would be interlocutory. If you do, if your opponent objects to your amendment, and then you must bring an application to amend, that would be an interlocutory application. An application to compel a party, an application to compel a party to
very nice.
I'm asking myself why I'm not at the door.
I was there, but I just couldn't.
Yes, we can all hear you. IJ, we can all hear you.
Sorry about it.
Okay. Yeah. So an interlocutory application, there are many interlocutory applications, but it's applications that is ancillary to a main action that's already in court. It's sorting outside issues while the main action is running. Okay. In some courts, you would put down an interlocutory application in the motion court. In Gauteng, I know, for example, they have a dedicated court that just hears interlocutory applications. So when you have an interlocutory application, somebody doesn't want to file the heads of argument in time. Somebody doesn't want to discover. Yeah, you go to the interlocutory, the court makes an order to compel them to do that. And if they don't do it, you can go back to court to have their pleading set aside. I don't know if I answered your question with regards to interlocutory application, sir.
Yeah, you did. Thank you.
Okay. Okay, thank you. I'm going to take the break now. I'm just going to see. Oh, Mary, Iluria. Yes.
Sorry, just oh dear, I've forgotten what I was going to say now, so you better just leave
I'm
it.
so sorry. I'm so sorry. It happens to the best of us.
Can I ask in the meantime?
Yeah.
About the costs, the request, the notice to ask for costs, is that not the same as then, you know, the same constitutional argument as if you, you know, as the provisional sentence argument in regard to costs? In other words, the person is too poor and you know, the plaintiff is just kicking the ball down the road so that he doesn't have his day in court to answer.
The security for costs. Is that what you're talking about? The security for costs. Yeah. Yeah, it is basically the same. Trying to keep the matter out of court because you know the person is not able to pay, but then you can go to in that case you can go to court and you can then tell the court that you have a prima and demonstrate to the court that you have a prima facie case, and then the court like the court won't close its doors if you have a case.
Okay, thank you very much.
Okay, sure.
Yes, Advocate, before we go on break, can I ask just two quick questions with regards to ex parte applications?
Yes.
Can you give us an example whereby an ex parte application is brought before the court where there is a respondent and there is no time to serve the respondent. And question 2, after the interim order has been granted in that circumstances, what happens to the order that's been granted, and after how long do you notify your opponent that there's an interim order?
Okay, 2 questions. The first question, I forgot.
Oh, so the first question was simply to ask for an example where
an urgent application.
An urgent application, for instance, spoliation would also be one of it.
But spoliation usually is heard ex parte, is it not? Yeah, but yeah, it's so urgent that you don't still have time for the sheriff to go and serve. Remember, there's all times the sheriff must go serve, and then they have so many days. There's no time for that because you need the relief now. That is an ex parte, but it's not an ex parte application. Just remember, I said people say they bring the application ex parte, but because the opponent is not in court. That's the only reason why they say ex parte. But there is an opponent. The papers will also show that there is an opponent. Then your next question was, when do you let the other party know about it?
Yes.
Well, the practice directions, and every practice direction that I have read says this. If you are going to bring an urgent application without the defendant or the respondent being in court, you have to at least notify them that you're going to court, be it by any means, social media, a call, a fax. You have to tell them, look, we didn't sort this thing out, because usually the court would be a last resort in an urgent application scenario. The court is the last resort because you try to settle it between yourselves and to sort it out. So now you run to court because you know now if I don't go, something bad will happen. You have to at least, the court says, notify the respondent that you're going to court and on what day you're going, when you're going to court, at what hour. So you must let them know, look, I'm going to court 10 o'clock tonight. If you don't want to listen, I'm going to be at court at 10 o'clock tonight. Even if they didn't receive the copy of the papers, they can then come to court and even be present in court, have an advocate or an attorney representing them in court, but they are not before the court because the evidence is not before the court. That is what I mean. They are not before the court. There's no story because the lawyer can't go and give evidence, and it's an application, so the evidence is in an affidavit. But then the court will give an interim order, and if the interim order the court will give an interim order which could be reverted back, and then you must be careful whether the person is actually going for final relief or for interim relief. But the interim order could then be reverted, and the respondent doesn't have to wait until the until the return day. The respondent can go to court 24 hours after the order was served on him, because part of the order that the court will give is that the papers and the order must be served on the respondents. Because how can they give effect if the respondent doesn't know what you're saying and that? And then the respondent can be back at court. He can anticipate an earlier return date 24 hours after he's received it. So he can be back in court the next day and say, this relief should never have been granted and it should not be made final because of X, Y, and Z. But then his evidence can be before court.
Oh, they don't have to wait for the release.
No, not if it's urgent for them to get the relief cancelled. They can anticipate an earlier court date 24 hours after the order has been served on them.
Yes, because the other party might be in a more advantageous position while waiting for the release.
And
yes.
Sometimes the release is 2 weeks or a month or whatever. The return day is long. Yeah, but you can anticipate an earlier court day. Remember, the courts have urgent courts every day.
Yes.
365 days in a year.
And any time.
While the court is not session, in 24 hours a day, the court is available. But for an urgent application, and I will talk to it later, but an urgent application must be urgent. It can't just be your self-created urgency. somebody must be dying, some house must be burning, and the fire must be put out. That's usually what they talk about when they say urgent. Otherwise, it's not so very urgent. But there are different degrees of urgencies, and we will speak to that later.
All right. Thank you so much.
Okay, sure. Are there any other questions? Can we take the break now? 15 minutes break. Okay.
The court pleases. 15 minutes break. Take my earphones. I take on gaming. Some voice guys. I thought it was some trap, but yeah, working perfect. Still working. Is it only? She's gone.
We are on a break.
Oh, okay, all right. Thank you.
You see, we have a formative assessment tomorrow.
Are you only asking now? Hey, my dog. Guys, can I ask you something? What do you think of these facts really? To me, they don't say much. Maybe I'll start to relate to once I see the questions tomorrow. It's just like it's just
On the
just like
platform. Are you even allowed to ask here on the platform, because you will be pleasuring and honoring?
Okay.
It's okay.
Maybe take
Yeah, and this is
it.
recorded, hey? Hello, everyone. This is recorded.
Yes.
So just be careful. This is
Okay,
recorded.
all right.
Put off your
All right.
microphones.
My apology, my apology.
I'm back, everyone. As you can see, I can now I can now use my slides. So I'm sharing with you, right?
That's correct.
Yeah.
Yes, we can
Good.
see.
Yes. So we're busy with applications, and like I said, it's rule 6. Okay. So there are 2 forms of notice of motions. The one is form 2 and the one is form 2A, A in brackets, small a. Lowercase a, that's how you call it. Now you will know that the short form, the form 2, is the ex parte application when there is only one party, right? And the longer form is where there is a respondent. The longer form is longer because you have more information. You actually tell the respondent that he must file an opposing a notice of intention to oppose and an answering affidavit. You tell him all of those details. That's why the longer form is used, right? Now, once a notice of motion and an application, the founding affidavit has been issued, and it is issued by the sheriff the same way like the summons. And it's served also by the sheriff exactly the same. So I'm not revisiting that. Once that has been served, the respondent has 10 days in which to file a notice of intention to oppose. Remember the notice of intention to defend? It looks exactly the same, but it's a notice of intention to oppose because now we're dealing with an application. Okay, it used to be 5 days, but it has changed last year, September 2022, there was an amendment. So if you have received the slides from Zukiswa, it will still say 5 days, but it should be changed to 10 days. So the respondent has 10 days in which to file and serve its notice of intention to oppose. And if there's no notice of intention to oppose, then the applicant can set the matter down in the unopposed motion court. And it mustn't be for a date less than 10 days after service on the respondent. Okay. But there's the practice directions of each division will tell you how to go about in securing a date on the unopposed roll, because they only take a certain amount of matters and different divisions have different ways. And I know in Gauteng they give you a temporary date and then it becomes final. Look at the practice directions in the division where you are as to how do you get your date that you set it down on the unopposed roll. That is now if the 10 days and you calculate it exactly the same like we did, only first day out, last day in, no notice of intention to oppose, you can set it down in court and it mustn't be less, the court date mustn't be less than 10 days after service. If there is a notice of intention to oppose, so the respondent says, I'm going to oppose, then you have to, sorry, it should be 10 here also. Notice of intention. If there is a notice of intention to oppose, then the opposing affidavit, or also called an answering affidavit, must be filed within 15 days after that. So in your answering affidavit, you will follow the same guidelines as you would have with a plea. You would admit, deny, confess, and avoid. But obviously, in your answering affidavit, you will give more information because remember, this is the evidence. Here you can plead evidence. Here you can state the evidence. And it's an affidavit, so it's somebody speaking. It would be I, the undersigned, you hereby state under oath. And then they will tell the story in their words. So that is how it's different to the action pleadings in that sense. And then 10 days after the opposing affidavit has been delivered by the respondent, the applicant can file or deliver a replying affidavit. Now, the opposing affidavit, interchangeably, people also call it an answering affidavit. Okay, in the rules, it is referred to as opposing. Let me see. and in the rules, it's called an answering affidavit. So people call it opposing affidavit or answering affidavit. It is the same. The first affidavit that the applicant files, they've referred to as the founding affidavit. Yeah. I don't think the rules mention founding affidavit, but people say that the application is founded on that document. Right. So further affidavits, if you need to file further affidavits, I explained to you yesterday, you can't, you have to ask the leave of the court. Then you once the affidavit has now all been filed, you ask for a hearing date, and then depending on the practice in those specific divisions, your heads of argument must be filed, and when it must be filed, you must check the practice directions of the division, because you have to file written heads of argument in applications. So when you come to court and you argue the matter, the court already has the papers, the court has the argument, and now counsel must just argue the matter, or legal practitioners for that matter must just argue the matter. Right, so the notice of motion, if there's an opponent, you use the long form. If there's any questions, just shout to me, because I can't see that screen and I don't know if there's a hand up.
Yeah, advocate, sorry, it's mine.
Yes.
I just want to ask something. Can you fast track this? So for instance, you get served an affidavit, you get served a summons, okay? Now, you don't have to wait 10 days. You respond almost immediately. So once you've responded, does the replying from, thereafter, you don't have to wait for the whole full 10 days to expire. No. You can fast track.
If you want to file a notice of intention to oppose on the next day, you can, or the day that you receive it, you can, and then file your answering affidavit immediately after that. And then they must count from the day that they received your one. So then they file a replying affidavit starting to count from the day that they received your one. So it's not the 10 days, and then you can.
It's the maximum. You got the maximum.
Yes.
Thank you.
Yes, 10 days is a maximum, but if you want to buy time, you'll wait the 10 days out. But if you're in a hurry, you do it quick. Yeah.
Okay. Thank you.
Sure. Is there any other question?
Advocate, can I just chip in?
Yes, you may.
When drafting the opposing affidavit, or I find it very difficult following the paragraphs of the yes, you admit, deny, and avoid, but where do you find time to in structuring your affidavit? Where do you find time to deal with your own version of the of the evidence, and how do you go about putting that? Because I can see you go paragraph by paragraph, admitting, denying, and avoiding, but how do you make sure that you put your version in the opposing affidavit?
Okay, so what you usually do is you will say, I, the undersigned Mr. X, to hereby state under oath, I have read the founding affidavit of the applicant, and I will respond to it as set out here under. Before I respond to it, they usually use the word ad seriatim, that is following each other. Before I respond to each paragraph, I will briefly set out my defense, my basis for my defense, and a brief background, so that the court can understand the context of my defense. And then you explain your background and you explain your defense, and then you say, now I will respond seriatim, and then you go at paragraph 1, at paragraph 2. So you do it before you tell your story beforehand.
Okay, thank you so much.
No problem. Are there any other questions? None. Right, so in the notice of motion, now the form is a form that is a form to the uniform rules. Now you have to draft the praise that in the notice of motion. So you will say, be pleased to, it usually reads like this: be pleased to take notice that an application will be brought by the applicant on whatever day, or as soon as the applicant will be heard, for an order in the following terms. Basically, that's how it reads. And then in the following terms, you will have your praise, whatever it is that you're going to ask the court. And remember, I told you that you would have the pray for costs, and you would have the pray for further and or alternative relief. Remember that in the exam, it's a tip. If you don't know what you're going to ask for and you don't have time to draft, just draft those prays, further and alternative relief. I don't know if you will get them out, but it will be right. Okay, so the affidavit, there's an example of an affidavit and a notice of motion on page 238 and 239 is the affidavit. It's a divorce. Huh? Oh, it's substituted service. Sorry that I said her. I was just thinking, but you can't get an application for divorce. And then there's one for a digital citation on page 242. So there is examples of what affidavits look like in your notes. Should you stuck in the exam, remember it's an open book exam. You can take this in, use it as your guide. How do I structure? What do I say? I will hereby make oath and say. Because in the affidavit, you would basically say that you say under oath and that the contents of this affidavit is true and correct and is in my personal knowledge. That's usually what they say. So in the notice of motion, you would, like with the summons, you would give it an address within 15 kilometers of the court period within which the respondent must deliver the notice of intention to oppose. So it's 10 days. When the matter will be set down if you don't deliver a notice of intention to oppose, and then the names of persons whose affidavits are annexed in support of the application. So you will say, in support of the relief claimed in this notice of motion, I annex hereto the affidavit of Mr. X. Okay. And that is now the notice of motion, right? And then it is signed. Is doing it themselves. You don't have to have right of appearance in the High Court to sign a notice of motion, and advocates don't sign notice of motion. I know somebody asked me the other day the question, I still don't have the answer. Can an advocate with a trust account sign a notice of motion? I still don't know the answer to that. Okay, and then it's addressed to the registrar and to the respondent or respondents, however many there may be. Right, that is now the long form, and then in the founding affidavit, that is now the affidavit that is in support of the relief requested in the notice of motion. You identify the deponent. Now, the deponent is the person who deposes to the affidavit. We call that person the deponent. Right? So you will say, I, the undersigned, do hereby state that I am whatever. If it is a person that is acting on behalf of a juristic person, he will say under which authority they have taken a resolution, and he will usually attach the resolution as proof. Right. Averment that the facts fall within his personal knowledge, the identity of the respondent, where the respondent is. So the same citations, you say who the applicants are. First, you say who you are, because you may not be the applicant. You might represent the applicant because you have personal knowledge of the facts, right? Then you will say who the applicant is, and then who the respondent is, and remember paragraphs, number the paragraphs. Then that the court has jurisdiction. For exam purposes, to include that, even if it is apparent that the court has jurisdiction. And then the cause of action, all the allegations necessary to make out your cause of action. So you tell your whole story now in your founding affidavit, right? And the facts which supports these allegations, obviously. And remember, because this is the only chance that you get to place evidence before the court, you can also here plead evidence. You will actually attach any documentary evidence, you will attach to the affidavit. So you will say, attached here to is the letter marked, and you will mark it maybe if it's a founding affidavit, FA1. Or what people also do, what the convention is, they use the initials of the deponent. So if the deponent is John Smith, they will say JS1, JS2 consecutively, however many annexures there are, right? And then the prayer, at the end, they end off, because remember, it's somebody talking, it's a lay person talking. What they usually also say at the beginning is, where I make legal averment, I do so on the advice of my legal advisors. They They qualify themselves. So if they're going to talk about laws and acts and stuff, if they're a layperson, they say that they got that advice from the legal advisors. So when they end off, they say that they pray for the relief in terms of the notice of motion to which the affidavit is attached. Right, so the documentary evidence is that, yeah. And then remember, the applicant is now, he alleged that all the facts are true and correct and falls within his personal knowledge unless otherwise indicated, right? Now, sometimes not all the facts falls within his personal knowledge. Sometimes he heard some of the facts from somebody else. So if John Smith is the deponent and he says, and then my employee Fred said X, Y, and Z, right? Then that is hearsay evidence. Now, we do know that hearsay evidence is not allowed. So you have to cure the evidence to make it not to be hearsay evidence. And how do you do it? You do it by filing a confirmatory affidavit also with that affidavit. Now, what is a confirmatory affidavit? If I said Fred said something in my affidavit, then Fred must also make an affidavit. Now, in Fred's confirmatory affidavit, he's not going to repeat everything that I said Fred said. Fred is just going to say, I read the affidavit of Laureen Abrams, and I agree with it insofar as it relates to me. That's all. So that means all the hearsay quality of that evidence has been cured, and it's no longer hearsay because Fred says whatever I say about him is true. So Fred's evidence is also before the court, and it's no longer hearsay evidence. Right. And there can be as many confirmatory affidavits as need be to cure all the hearsay evidence. Because if you say something that somebody else has said, you don't have personal knowledge and you can't give evidence about it. It's hearsay. Right. And then the respondent files an answering affidavit. Again, the same rule applies. If you're going to leave any of the allegations out, it's deemed to be an admission. So all the allegations in the founding affidavit must be addressed, admitted, denied, confessed, and avoided.
Sorry, Advocate, can I bother you for a second? Sorry. I'd just like to know if, well, usually claims for damages in respect of a motor vehicle accident would be under an action proceeding. Now, if
that's correct,
yeah, if you have at your disposal, well, you've suffered damage. The damage is quantifiable through maybe your car has been written off beyond economical repair, and the difference between what the insurance pays out and what you've suffered is the damage. Let's just say 100,000 Rand. And the accident report drafted by the police and the metro officials indicates that you were not at fault. The other driver was driving under the influence of alcohol, and the accident was solely, or not rather solely, but the other driver was the cause of the accident. Would it be advisable to actually proceed with the claim on an application as opposed to an action in that regard?
It is mandatory for all claims of damages to use the action procedure. You don't have the choice.
Okay, thanks.
Okay, sure. Okay, so in the answering affidavit, you must admit, deny, confess, and avoid. And if you don't know, you don't know. You can also add annexures. You must set out your defense and the facts supporting it. That question that I had earlier on, we usually start by setting out the defense and the background and our facts, and then we say, now we're going to deal with the allegations of the applicant, and then we start doing that. So if you deny anything, substantiate your denials. Don't just do a bare denial and saying, I deny the contents of this paragraph. If you substantiate, say why you deny it. And then the applicant files a replying affidavit 10 days after the answering affidavit. In the replying affidavit, you cannot bolster evidence in the founding affidavit. You are limited to response where necessary to factual allegations by the respondent in the answering affidavit. Okay, so you don't have to deal with each and every allegation in the answering affidavit, in the replying affidavit. The two most important affidavits is the founding affidavit and the answering affidavit, because therein we're going to see what is in dispute and what is admitted evidence. Right. The replying affidavit is just dealing with issues that you didn't deal with. Okay, so I've already told you about this ex parte application. And we've looked at interlocutory applications. So, yeah.
May I have a question, ma'am?
Yes, you can ask.
Yes, ma'am, when the confirmatory affidavit is now attached, will that person not be required to come and testify in future?
No, there's no testifying. There's no oral evidence led at the. There's no oral evidence being led at the in an application. The evidence is there before the court. The court decides the matter on the papers.
All right. Okay. Now, thanks, ma'am.
Okay. I seem to be missing any very important slides here. So I'm just trying to find it. Because I didn't start at the beginning. So here's it. Right. So we did that. Sorry. I just don't want to miss that because I need to do that. And if it's not here. Yeah. Okay. So in your yes. I said when you are sitting in your consultation and you have to decide. Now here we are looking back as to when you have to decide. Remember, I told you that there is some mandatory cases where you have to use either the application or the action, right? And then I said there's a gray area where you have a choice. Now, people would really like to choose the application procedure because it's a quicker procedure, quicker than the action procedure, because you don't have to go through all of those steps to get your matter heard. But when do you decide that the matter that you must use the application procedure? And we said when we did actions is there a dispute of fact foreseeable that can't be resolved on the papers, then you must use the action. And if it can be resolved on the papers, then you must use the application. But still, you can still make the wrong decision, right? So when do we decide when there's a dispute of fact? And this information I got from that famous case, Roomhire versus Hcp Street Mansion. Some of you might recall, it might sound familiar to you. That's where they decided this, when a dispute of fact arises. So the court said there that a dispute of fact arises where the respondent denies substantial factual allegations of the applicant and makes conflicting factual allegations against those of the applicant which the applicant denies. Right? Where the respondent admits substantial factual allegations, but on the other hand, alleges facts which the applicant disputes, then there's a dispute of fact. Where the respondent alleges that he does not have knowledge of the allegations made by the applicant, but that the applicant or his deponents are unreliable, untrustworthy, or prejudicial, and that certain facts upon which the applicant relies to prove the main facts are untrue. Where the respondent merely denies the allegations made by the applicant without making any counter allegations, there's no real dispute of fact, right? So here we are looking back. The applicant has used the application procedure, right? Now, how do we see that there's a dispute of fact? We look at the founding affidavit and we look at the answering affidavit. Now, we look at the answering affidavit and we check what does the respondent admit? And everything that the respondent has admitted, that is a that is common cause fact, or that is not in dispute, right? And then we look at what does the respondent allege further? And if the respondent alleges stuff further that is now contrary to what the applicant is saying, then we have a dispute of fact, right? If the respondent alleges that he doesn't know what the applicant is talking about, that they are lying, then also he's alleging that they are lying, then there's a dispute of fact, because then the veracity of the evidence should have been tested by way of cross-examination in court. You see, there's a dispute of fact, and the action should have been used. A mere denial by the respondent, there's no dispute of fact. He's just denying it. He's not making contrary allegation or saying something else that would say that he has a defense or that there is a dispute. He's not saying that. And he's not even saying they are lying so that we can test their evidence. He's just merely denying it. Then there's no real dispute of fact, right? Now, what does the court do when on the papers you've used the application procedure and on the papers there is a dispute of fact? What does the court do? So if you've chosen to use the application procedure and now it appears on the papers that there's a dispute of fact, the court can dismiss your application, and that is the worst that the court can do, because then you lose. Then if you're the applicant and you've chosen the wrong procedure, and now because of that, then you lose. Are the questions? I hear some sound.
Yes, advocate.
Sure.
You say that should it happen that you choose the wrong action, the court might dismiss
wrong
your action when you
process,
lose the
yeah.
case. Okay. Now, is there a possibility of converting the application proceedings into action proceedings without having to go through the pain of losing the actual case?
Yeah, there is.
Oh,
I'm
okay.
coming
So,
there. I'm coming there.
oh,
Yeah. Okay, you will apply for that. If you see that there's a dispute of fact, you can apply for that. The court can also refer some of the aspects that are in dispute to oral evidence. So it remains an application, but the court says, look, I want to hear this witness. Then it refers the application to oral evidence. That's what the court can do. And then your question, sir, the court can refer the matter to a trial. So the court can then say, okay, there's a dispute of fact, a real dispute of fact, and we're going to refer to trial, obviously, because somebody applied for that. You make an application and you convince the court that it wasn't foreseeable at that time, but now there's a dispute of fact and it should be a trial, and then it can be referred to trial. Then the founding affidavit will then be the particulars of claim, the answering affidavit will be the plea, the replying affidavit will be the replication, and then the parties will conduct themselves as they would in an action. There will be discovery and there will be all of those other steps, right? Or the court can determine that the application, where there's a dispute of fact on the papers, in accordance with the Plascon-Evans rule. So you can also argue that the court must determine it in accordance with the Plascon-Evans rule. Now, I'm sure a lot of you by now already know what the Plascon-Evans rule or Plascon-Evans principle is. We saw it on that interviews at the JSC, where a lot of people didn't know what the Plascon-Evans rule is. The court, now what is the Plascon-Evans rule? I'm going to tell you now. The court is entitled to deal with the application on the undisputed facts, right? So stop there, the undisputed facts. How do we know what is the undisputed fact? You are now the applicant. You've brought this application. There are facts in dispute, and you are now going to try your luck and say, we must deal with this in terms of the Plascon-Evans principle. My lord, the undisputed fact is the following. So you look at the answering affidavit of the respondent, and whatever the respondent says, I admit, I admit, I admit. You tell the court, this is the undisputed facts. X, Y, Z. We are not fighting about that. Those are common cause facts, right? And the court will deal then with it there. Then, if notwithstanding that there are facts in dispute on the papers, the court is satisfied that the applicant is entitled to the relief in view of the facts stated by the respondent, together with the facts in the applicant's affidavits, which are admitted or have not been denied. it will make an order giving effect to such finding. That is a mouthful, but let me spell it out for you. So the court look at what is common cause facts, right? That is the undisputed facts. Then the court look at what does the respondent say further. So the court totally ignores what the applicant says. The court look at, okay, the respondent admits these allegations. So this is the common cause fact. Then the court looks at what does the respondent say further. Does the respondent really have a defense to this relief with what he says further? And if the court says no, but he doesn't, this common cause fact, the applicant should get what he's asking for. So then the court will say, applicant, you get your order. You get what you're asking for. It's as simple as that. That is the Plascon-Evans principle. It was decided in this case, Plascon-Evans Paints Limited versus Van Riebeeck Paints. It's a 1984 and it's an SCA case. Okay, so it's almost 20 years old. No, not 20, 40. Yeah, almost 40 years old now. But it's still applied. And I've got a approach that was taken in the National Director of Public Prosecutions versus Zuma, our ex-president. It was in 2009, where the court said the following in paragraph 26. Motion proceedings, unless concerned with interim relief, are all about the resolution of legal issues based on common cause facts. There's some disturbance at the back. Unless the circumstances are special, they cannot be used to resolve factual issues because they are not designed to determine probabilities. It is well established under the Plascon-Evans rule that where in motion proceedings, disputes of fact arise on the affidavits, a final order can be granted only if the facts averred in the applicant's affidavit, which have been admitted by the respondent, together with the facts alleged by the latter, the respondent, justify such an order. It may be different if the respondent's version consists of bold or uncreditworthy denials, whether it raises fictitious disputes of fact, is palpably implausible, far-fetched, or so clearly untenable that the court is justified in rejecting them merely on the papers. Yeah, so that is what the Plascon-Evans principle is. Do I have any questions on the Plascon-Evans principle?
Ma'am,
do you all understand it?
I'm asking you to repeat it because I think there was some echo, you know, I don't know what's happening, whether maybe it's...
I said, was it from my side?
Yeah, it was on your
I
side.
heard the echo. I didn't know. Was
If
it on
you
my
can
side? Oh, I'm so sorry.
Yeah,
Okay.
thank you.
Okay, I'll do that. Apart from that, is there any other questions?
I say we're scared to say yes, we understand it.
Are you scared to say yes? Okay, let me just hit it. Should I go through the whole thing again? Okay, I'm just going to start with the, okay, just remember, if there is a dispute of fact that arises from the papers, the court can deal with it in one of four ways. Dismiss the application. You don't want that to happen. Refer some aspects to oral evidence, or refer the whole application to a trial. And lastly, determine it in accordance with the Plascon-Evans rule. You can argue that Plascon-Evans rule, right? What is the Plascon-Evans rule? The court is entitled to deal with the application on the undisputed fact. So you take your founding affidavit and you take your answering affidavit. You check what the respondent admitted. You argue, you say, my lord, the following are not in dispute. The applicant admits that I can do X, Y, and Z. The applicant can admit that that is my right. The applicant admits this, the applicant, whatever is admitted. And then you look at what does the respondent say further. Because it says, if notwithstanding that there are facts in dispute on the papers, the court is satisfied that the applicant is entitled to the relief. Now, this is where it is. In view of the facts stated by the respondent, together with the undisputed facts. together with the facts in the applicant's affidavit, which are admitted. So what does the respondent say further? First, what does the respondent admit? So that is undisputed. And what does he say further? Does he take his case anywhere further? Or should the applicant get what he's asking for based on the common cause facts, and what you say further doesn't really take your matter further, but the applicant should get, and then the applicant will get what they want. That is basically it. And then I said to you how it was set in motion. Motion proceedings, unless concerned with interim relief, are all about the resolution of legal issues based on common cause facts. So it is not designed to determine probabilities. It is only common cause facts. And if we agree on certain basic things, we look at what you say further. And if what you say further doesn't take your defense any further, then the applicant will get the relief that they're asking for. Okay, so now I'm going to ask again, are there any questions on Plascon Evans? Will you be able to argue that in court? Mondisi, no, Mkolisi. Mkolisi. Radebe, Khadebe. Mkolisi Khadebe. Yes, your hand is up. Is it the old hand? This is the earlier hand.
So, advocate?
Yes.
Is it literally based on the, say for instance, the founding affidavit says this, S, Y, and Z, while say for instance, the replying affidavit, the respondent admitted, and then you will use the Plascom.
Yes. You will argue it on the common cause fact, but then you must also check on what does the respondent say aside from the admitted facts. What does it say? Does it mean that the applicant shouldn't get it? Does it take the respondent's defense further, or does he really have something that is worthwhile that the applicant should not get what he's asking for?
Okay, so say for instance, the respondent admitted some important facts, but then dispute some minor facts, then it wouldn't have any effect with respect to what the applicant is asking for.
Yes, if it's a minor facts, that doesn't, yeah. It depends on,
Okay.
yeah. So you will argue that. And
All
then
right.
you will be successful. If there's a dispute of fact on the papers, you've chosen the application. There's a dispute of fact, you argue in terms of the Plascon Evans rule. That is how you're going to argue it. And
Right,
then you're
thank
going
you,
to court
advocate.
cases. Okay, so you all understand it. Eh? It's not difficult to understand.
Advocate,
Yes.
does this suggest that the Plascon Evans rule deals only with the common cause facts and exclude the interpretation of any statute or act?
I don't understand your question. You say it doesn't, what about the interpretation of a statute or act?
I'm saying that this rule deals only with the facts.
Yes,
and
it's on the facts, the common cause facts. What do we agree on? What is common cause? Because if I say the act says X, Y, and Z, the respondent agrees with me that the act says X, Y, and Z. How can the respondent say the act doesn't say X, Y, and Z?
Okay, no, it's there.
But you mean in the manner of interpretation? That's for the court to interpret law. Okay. Yeah. So if the respondents say the act X, Y, and Z in the act doesn't mean what the applicant says, the court will say no, but it does mean that. So that is the further thing that the respondent said. It's not common cause. That is what he says further, but what he says further is nonsense, really, because the court interprets the law. I don't know if that makes sense to you.
Yes, you do.
Okay. Any other questions? There's a hand up, but I don't know whose hand it is. Oh, there's no hands up. Okay, so we move on. Right. Moving on. I did that all already. Okay, now we come to specific applications, and I touched on urgent applications. I just want to go more into urgent applications. Like I've already informed you, the courts are always available for urgent applications. There's always a judge on duty. They on a rotation basis. Each judge gets a week where him or her is on duty. So there's always a judge on duty. And if you have to approach the court at any time, even outside of normal court time, then you can, providing that it's urgent, right? So in terms of Rule 6, sub-rule 12, urgent applications are heard, right? And what you would usually ask, the first thing that you would ask in your praise, so in your notice of motion, you would ask that the matter be regarded as urgent. And then you would ask the court to condone your non-compliance with the rules. Because you are not going to, your rules of service, you're not going to let the sheriff serve the first process. That is the rule. You want condemnation for not complying. The respondent has 10 days in which to file a notice of intention to oppose. You're not going to give him 10 days. Yes, then 15 days to file an answering affidavit. Nothing of that is going to happen. So you ask the court to condone the non-compliance with the rules. You ask that the court regard it as urgent, and then you praise what it is that you actually want. Okay, and then further an alternative relief. Then remember, there are different degrees of urgency. Sometimes you have to approach the court outside of court hours in the middle of the night, and you can't wait for the next day. So what usually happens is at court, they would have they have the judge who's on duty for that week. Every week that it rotates. So they would have the registrar also on duty, and the securities at the court would usually have these people, the registrar's details. You would call the registrar and say, I want to bring an urgent application. This is now if it's outside of court hours. I want to bring an urgent application. And the registrar will ask you, why is it urgent? Because that is the first thing that the judge will want to know. Why is this matter urgent? Where is the burning house? Or who is going to die if I don't give the order now? And that is very urgent. That is where the court will come out in the middle of the night and then hear the application. If the application can be heard the next day or the next week, and it's not so urgent, the court will then say, but why? Why not the next week or whatever? The court won't just, because you now think it's urgent, agree with you. You have to convince the court that it's very urgent. So different degrees of urgency commensurate with the different degrees of relaxation of the rules. Because sometimes a matter is urgent, but it's not so very urgent that you have to bring it now. So you're going to bring the application next week or next month. Remember, you wait for a court date for a normal application that is opposed. You wait at least 2 terms. So 6 months or so, you wait for your date for an opposed application to be heard. That is the least amount of time, 6 months. So if a matter is urgent and you bring it timeously, but you need to bring it within 2 weeks' time, you can serve the paper still, the sheriff can still go serve it, but then you can shorten the times. You can still abridge the times. You can say that you must, the respondent must let me know within 1 day that he's going to oppose, and within 3 days he must file his answering affidavit. You know, just to let everything be before the court, but you shorten the days. And you as the applicant choose the days, but you mustn't be unrealistic or unfair, because the respondent will argue in court that you were unfair because it's not so urgent that you had to shorten the days to that extent. And they were under pressure in preparing the documents and all of that. Is there a question? So degrees of urgency and degrees of relaxation must commensurate with each other. Where life, liberty, and bodily integrity is at stake, then obviously it's more urgent. If it is a commercial interest, somebody's going to sell something. If you can still sue that person for that money, it's not so very urgent. The court won't regard it as urgent if as so very urgent if you can still sue the person for whatever money, if money is going to be lost. That can always be remedied. You still have a claim. Can that person whose microphone is on please put it off?
Zukiswa?
Is it Zukiswa?
Yes.
Zuki, your Zukiswa, your microphone is on. No, it's not. Oh, she put it off. Okay, so just remember that yeah. I don't know what I was saying last, but I was talking about the urgent application. So if it's not so very urgent, but it is still urgent, you can have different degrees of relaxation. Yes. And you must still ask the court to relax the rules because you still want to, because in an urgent application, what you are doing is you are saying to the court and to the country, my matter is so urgent that I don't have to stand behind in the queue of every other litigant in the country. I must get preference. I must go ahead of all of them, and the court must hear my matter because it's so very urgent. So to get that indulgence, the matter must in fact be urgent. And in your application, you must describe why the matter is urgent, and that if you don't get the relief immediately or when you say you need the relief, huge damage will be suffered. So because you are asking for a big indulgence, you have to explain that to the court because you are going ahead of each and every litigant who is doing the matter in the normal course and waiting for their time when their matter is going to be set down and all of that. Okay. So in the notice of motion, you would, yes? Yes?
I've seen that in the urgency list, we see live bodily injuries and what have you there. But I have cases where most politicians have used this urgency to get their cases heard as quickly as possible. Can you just maybe shed some light with what we will consider urgent in these applications so that we can, kind of like try to understand exactly what will constitute urgency in these court matters?
Yeah, if you can give me an example where politicians went to court with an urgent application, then I can maybe try and answer you.
Like, for instance, in election matters, say, for instance, election matters in the constituency election, where maybe there is going to be election for, say, for instance, mayor or whatever. Then they will go to court and say, no, it's an urgent matter. We want an interdict and all that.
Okay. So then there's a date where the election is already, the date has already been established when the next election is going to be. And if they want to stop something from happening before that, then it is urgent.
Yes.
Yeah, then it is very urgent. The court will only entertain it as urgent if you didn't create the urgency yourself. By creating the urgency, I mean, you knew long ago that this is going to happen, and now you wait until the day before it happens, and then you want to run to court. That is creating your own urgency. So the court will then say that is not urgent.
Yes, because most times the court will say, no, you've known about the date for this election, you didn't do anything, but now the election is tomorrow, you're coming today to say, no, we have to interdict these people. But the court will refuse that application.
Yes, you understand it perfectly, because that is self-created urgency, and the court won't indulge you if you create your urgency self. Yeah.
Right, thank you.
Okay. Any other questions?
I just wanted to ask, regarding the Al-Bashir issue, wasn't there, if memory serves me right, there was an application, urgent application around the Al-Bashir issue?
What issue? Sorry, maybe I don't know what you're talking about.
Al-Bashir issue.
What issue is that, sir? Oh, Bashir, that one that was yeah. But then he was already out of the country when they gave the order or something like that. If memory serves me correct, wasn't it?
Yeah, you're correct, ma'am. But what I'm asking is, I think there was some form of application at the time, urgent application.
And then what happened? The court grant the application. Did the
I'm
court
not
say
sure
it was
about the
urgent?
details, but I just know that he ultimately disappeared into
By the
oblivion.
time the court made the order, he was already out of the country. That's what I know. Yeah. Yeah. I can't comment much on that, but I do remember something about that. But it wasn't effective because by the time the court gave the order, he has already left. Yes, anything else?
Maybe I think if my recollection serves me well, when the first application was made, he was still around, and then I think then he escaped, and then there was another application, and I think that is where government were like, no, we also want to remove ourselves from the Raymond statue and things of that nature.
Oh yeah. Look, I'm not so clued up on that. I just know what I saw on probably on social media, and that I can't really comment fruitfully on that. But yeah, that's all I can. If there's anybody else that want to contribute to that can shed some light, that knows more about the application, please go ahead and do that. Okay, so let's go ahead. Interdicts is usually an urgent application in the form of an interdict. The common scenario is that you oblige someone to take action by means of a mandatory interdict, which is called a mandamus if the action is required by a state official, or you oblige someone from refraining to do something, right? And then we have the requirements from your studies, your substantive studies. You would know the requirements if you look at the bottom of this slide. You would know the requirements. If it's an interim interdict that you are asking for, you must meet these requirements. First of all, that the applicant has a prima facie right, that the grounded of irreparable harm, and that the balance of convenience favors the granting of the relief, and that there's no other alternative remedy. If you are asking the court for final relief, then you must demonstrate a clear right, an injury actually committed or reasonably apprehended, and that there's no alternative remedy. So basically what you would do if you would bring this application. Okay, let me just go one step further. On your where is that now? In your manual, there is on page on page 207. 207, there are self-assessment questions. Now, question A, that question, right? If we were now in a classroom scenario, I would have asked you to draft that. That is the question. Your client is Mr. F. Brown, a farmer who used a road through the neighbor's farm, Mr. S. Chicks, for the past 5 years to get access to town. On the Monday morning, your client discovers that Mr. S. Chicks has put a gate on the road and locked it. Mr. F. Brown urgently needs to deliver stock to town, and if he cannot, he will lose a big contract. You advise your client that he can bring an urgent application, draft the notice of motion and supporting affidavit, including the heads, and making up your own facts where necessary. Okay, that is the question. So this is what the heading look like. Okay, the notice of motion. And you would then state in the notice of motion the following. So you have the slides. Don't have to worry about it. You have it. It's just you ask the court. Be pleased to take notice. Sorry, kindly take notice that an order in the following terms will be made. right? And then the prayers are that the application be treated as an urgent application and that the court dispense with the normal rules. Okay, that is just putting it mildly. You can put it in two different paragraphs also. The urgency in one and the court dispensing with the normal rules of service and etc. in the next. And then that the respondent be ordered to give access to the applicant to the road and in the name of the road. Alternatively, that the sheriff be authorized to give access to the applicant. And then that the respondent is ordered to pay the cost. You would also have further and alternative relief, which I don't have here, but you would have that pre also. It's the High Court. Right? And then in your, oh, I do have it. And then kindly further take notice that the affidavit of Mr. F. Brown will be used in support hereof. And then you would also have, it would obviously be signed and sent, and the fact that they have the right to file a notice of intention to oppose, and you would have shortened the time. And then when you do the founding affidavit to describe it, usually you start like that personal knowledge and describing the parties, right? And then I just have headings here. So you will say why the court has jurisdiction. Then you will make the factual allegations. Now, because we are dealing with an interdict, you want somebody to do something, to be ordered to do something. You must meet the requirements, and it's a final interdict, so you must meet the requirements of a final interdict. So you will say the clear right. What is the clear right? I have right of way over the farm. I've always had that. It's a servitude, whatever. Look at the facts. Then you will also say, what is it? What is the other requirement? The imminent harm already or committed or about to be committed, reasonably apprehended. I came to the gates, it was locked. The facts will give you all this. I came to the gate, it was locked. And then you can also add some information. Maybe I tried to call him. I said he must open it. He said, no, he don't want to open it. I said, what can I do? I will have to go to court to let you open it. All of that. And then say that this is the last resort. That is the third requirement. So you will say no other alternative remedy. So you will say why the court is the only forum that can help you with a court order. And then you must describe why the matter is urgent. Okay, he said he must go and deliver stuff in town, his business and all of that. So he describes why it's urgent. And then you have your then you have your interdict, your application. So that is how you would draft it. Right. Any questions on that?
Yes, Advocate. My question will be on dates. When you're answering when you're writing exam, is it for the marker wants exactly the dates, or you can just write the dates, or you must write exactly the date, counting days, 5 days or 10 days, and expecting you to return an opposing affidavit on these dates?
You the data you to see if you can calculate. It depends if that is going to be the question that is going to be asked. But you if they give you a specific date and they say within 10 days, and then they want to see if you know how to compute, just know first day out, last day in, count court dates if it's in terms of the rules. And you would have your, wouldn't you have your accents that it's an open book exam, so you would have the stuff there. The information you will have there.
Thank you so much.
Yeah, it's an open book exam, so you don't have to remember. You just have to remember where to look for it.
Okay. So just calculate and then minus those
yeah,
holidays or those days.
Yeah.
Okay. Thank you.
If they should if they should want to test your knowledge on that. Yeah. Yeah. Another specific application is an interpleader. Okay, it's a rule 58. So I'm going to quickly, we're running out of time, so I'm going to quickly just tell you when you use an interpleader. If a person expects to be sued by more than one person for a specific thing, right? And I'm talking now in my own words, and the person knows that I owe somebody this money or this duty, I owe it to someone, I can't just determine who. Then that person serves an interpleader. And this is where you use the specific application. You serve an interpleader notice. The notice must state the nature of the liability or the claim, which is the subject matter of the dispute. You call upon the claimants to deliver particulars within the time period indicated, not less than 15 days from the date of service, and state that you will apply to court for a decision of as to the liability. To who do I owe this money? And I'm going to give you an example now. In the affidavit by the applicant, he sets out the fact and state that he claims no interest in the subject matter other than for charges and costs. He does not collude with any of the claimants. He's willing to deal with the subject matter in dispute. On delivery of the notice, if the claim relates to money, he pays the money to the registrar. If it relates to a thing that can be delivered, he tenders that to the registrar. And if it relates to immovable property, he places the title deed in the possession of the registrar, and he says he undertakes that he will sign any documents that the court might direct him to sign. Now, the example that you have in your notes is a good example. I'm going to just explain it to you. A farmer wanted to sell his farm, right? He put his farm on sale. An estate agent came to him, and the estate agent, he told him, look here, I'm looking for a buyer, right? They went away. Like a few weeks later, the same estate agent came to him and said, I've got a buyer for you. The farm is sold, right? Unbeknown to the farmer, the estate agent, when he came the first time, he was employed by one agency. And when he came the second time, he was employed by another agency. Both of these agencies now want to claim from the farmer, the commission. The farmer knows he must pay the commission. He don't have a problem with that. That is not his problem. He just don't know who he must pay it to, because if he pays it to the wrong person, the other one might sue him successfully in court. So what does he do? He serves an interpleader. Both of them must go to court. The court will then determine who is to who the farmer is liable. The farmer doesn't collude with anybody and all of that. Are there any questions on that? I've quickly explained it in my own words. Do you all understand that?
Advocate.
Sure.
Would it be the same in a situation where a sheriff would have attached someone's property
Exactly
and another
the same.
person? Oh, okay.
Exactly the same. That is in the magistrate's court, it's used a lot by the sheriff, because the sheriff comes, he's got a warrant of execution. He comes to your house, he writes up your stuff. You borrowed your brother's car, it's in the garage. The sheriff writes it up. He doesn't want to hear it's not your car. Your brother says, I want my car. Your creditor, the bank says, no, he owes me that money. We must sell the car to get the money. So there are two people who's claiming the money, who's claiming that. The sheriff serves an interpleader. They must go to court. The court will decide who is the rightful owner. To who must the sheriff give the car back? To the creditor, to judgment creditor, or to the brother who says he's the owner? Yeah, exactly that position. Okay,
right,
any other questions? Just know that if you get a question that they say 2 or more people have a claim, look at that notice. Don't now draft the urgent application or that draft the wrong documents in the exam. Just know that is interpleader, because 2 people have, what must I do? Notice, and there is an example in your notes, so look at that example. Right, the next application that we look at is the appointment of a curator. We spoke about this. I would advise you all to look at to watch that movie. I Care a Lot. It's on Netflix at the moment. It's got to do with curators, right? So the appointment of a curator, where somebody is going to be declared of unsound mind or incapable of handling his or her own affairs, right? In the application for the appointment of a curator, anybody can bring the application that is close to the person. Now, this is where a person has maybe been in an accident or suffered a brain injury and can't do its own business, its own matters, or a person has been diagnosed with Alzheimer's or dementia. We have a lot of those kind of matters, and where people have properties and businesses, and then they can't even sign a power of attorney to somebody to do it on their behalf, so a curator must be appointed. Now, when a curator is appointed, it is a twofold, it's on two legs. You must go to court twice. Before a curator, Bonies is appointed, who will handle the affairs of the person who is of unsound mind. The court must first appoint a curator ad litem, right? Now, the application can be brought by any family member, caregiver, or even an attorney can bring the application, right? So in the notice of motion, and it's usually the short form because there's no opposition, you will ask that the first, when you go to court the first time, you will ask that the curator ad litem be appointed. They usually appoint curator ad litems from attorneys or legal practitioners as use. Attorneys and advocates are usually curator ad litems, right? And in the founding affidavit, the applicant must state why he's applying for this appointment of a curator, and his relationship towards the client, to the person to be declared of unsound mind. Now, from here on to forward, I will refer to that person as a patient, because in the papers, they refer to that person as the patient, okay? The person to be declared incapable of handling his or her own affairs. So the patient's particulars, the relationship between the applicant and the patient, and the reason why the patient needs a curator. The particulars of suggested curators. So the applicant will say that Mr. X has indicated that he's willing to be appointed as the curator ad litem, and Mr. Y has indicated that he's willing to be appointed as a curator bonus, if the court should so appoint him. And then you will have the consent forms of those people. They've signed a consent that they are willing to take that position should the court appoint them. And then any relationship to the patient must be disclosed. So all the patient's particulars, his status, his age, when he was diagnosed, or how he became the way he is now, and also the extent of the estate of the person. Does he have a business that must be run? Does he have immovable property that must be sold, or anything like that, right? Also attached must be and this is very important, because this is an inroad into the privacy of a person, right to handle his or her own affairs. So it's a huge thing. If you watch that movie, you will see they are totally then divorced from all of their own affairs, and somebody takes care of everything. So the court doesn't easily give this kind of order. You must also, to the application, attach 2 medical practitioners' affidavits. And in the affidavits, they must state, each one separately, that they have recently examined the patient, and that in their opinion, the patient is incapable of handling their own affairs. Now, one of those 2 medical practitioners must be a head doctor, like a psychiatrist or a neurosurgeon or a neurologist. One of them must be that, and the other one can be a general practitioner. So 2 medical practitioners, independent of each other, must also tell the court that this person can't handle his or her own affairs. Right, and then at the hearing at the first stage, I said it's a twofold time. First, they appoint the curator ad litem, right? Now, when the court appoints the curator ad litem has certain duties. Now, the curator ad litem main duty is to recommend to the court who is the most suitable person to be appointed as the curator bonus. Most important. So he must do an interview with the patient, make all the necessary inquiries, get all the corroboration, and speak to other people. He can also speak to the medical practitioners to find out if they have anything further to say. And then he prepares and he files a report. Now, this report he files at court and at the Master of the High Court. Right? Now, and he then, in that, he makes a recommendation. He also looks at who has consented to be appointed as the curator bonus? Is that person suitable? And he looks at other people also. If he thinks that person is not suitable, he will then make a recommendation in his report. The master, when the master receives his report, look at the report, and the master will then say if the master is satisfied with whoever he has recommended. Now, in terms of the Administration of Estates Act, the master requires that whoever is appointed as the curator bonus, whoever is going to handle the affairs of the patient, that person must give security to the value of that estate. So say the person has been brain injured in a motor vehicle accident and he's going to get a payout of 5 million rand. That person must give security for 5 million rand. That is what the master requires, because the master wants that money must last for as long as that person lives. And that the master wants to make sure that that person have a security for that money should anything happen to that money. So then family members usually fall by the wayside and they can't be appointed. You get people that has those kind of insurance that can be appointed, but the master waives the requirement for security if the curator bonus to be appointed is an attorney with a valid fidelity fund certificate. So in many cases, attorneys are appointed as the curator bonus. Some attorneys does this. They get then paid from the estate a certain amount, and they must also report quarterly to the master as to what they have done with the money. They have all the powers. They can invest the money, open businesses, and also in consultation with the caregivers of the patient, see to the day-to-day needs. So if the house must be extended, if a vehicle must be purchased, for the maintenance of that person from that money, and also work with the money and report to the master. And for as long as that person has that security, the master will be satisfied. So the curator ad litem recommends the person, and if the master, he then also files a report to the court, the master, and then the matter is set down again. Now, in addition to everything that was already before the court, there is now the curator ad litem's report and the master's report, and then only if the court is satisfied will the court then appoint the curator bonus, who will then take charge of the person's estate and will deal with it as is with all the powers that he has. Do I have any questions on that? That was now a mouthful.
What happens, advocate, if the patient regains his or sanity?
If the person becomes capable again, becomes fit, yeah. Then the rule actually makes provision for having it overturned. But then you must again, I mean, you have two medical practitioners that would have stated that this person is incapable of handling his or her own affairs. So then obviously that then their prognosis was wrong and the person can then handle their own affair, his own affairs. So then I think you must have doctors also to state that the person is capable of handling his or her own affairs. Yeah, there is an application that you can bring to overturn it. It's not that you are bound, but I suppose it would be very stringent to application. I'm just trying to call up the rule so that I can just tell you what the rule says. Yeah. So any other questions while I'm trying to get to this rule?
Who incurs the cost?
Who? The estate.
The
estate. Yeah. The estate incurs the costs. Any person, okay, but let me just see. I am but the rule 57. Let me just see. It's rule 57. Oh, in 57:14 says, every person who has been declared by a court to be of unsound mind and incapable of managing his or her affairs and to whose person or property a curator has been appointed and who intends applying to court for a declaration that such person is no longer of unsound mind and incapable of managing his or her own affairs for release from curatorship, as the case may be, shall give 15 days notice of such application to such curator and to the master. And then that person must then probably medical evidence. They don't say what you must have. They just say upon the hearing of an application in terms of sub-rule 14, the court may declare the applicant as not being of unsound mind and as being capable of managing his or her affairs, order the applicant's release from curatorship or dismiss the application, or of its own accord appoint a curator ad litem to make inquiries as it considers desirable and to report to it and call for further evidence. So the court has the discretion to ask to call further evidence. So you can actually be released, bring the application to be released. It doesn't say you must have doctor's reports, but the court can then say, this is what I need in order for me to be convinced that you should be released. Just read 5714. Did I answer your question, sir?
Yes, thank you so much.
Yeah. Okay. I've went way over time and I'm not yet done. So yeah, that is where we are. Do I need to go on or what do we do?
Advocate, we have exams tomorrow.
You need to be released. I think
Yes.
read through the rest of your notes, what we didn't cover. It's not a lot. And the slides, it's not a lot anymore. It's about, yeah, it's about 20 slides.
You can send us your slides, Advocate.
Yeah, it's Zukiswa said she sent it to you already.
Okay, thanks.
There's about 20 slides left, yeah. So just look at it and read your manual. You'll do okay. It's all, read your manual, know where the stuff is. If you're in the exam, you know where to look.
Thank you.
Okay then.
Okay. Yes.
Yes, have a nice weekend and a
Same
nice
to you.
exam.
Thank you
Thank you,
very much.
Advocate.
Thank you.
Thank you.
Thank you. Thank you very much.
Thank you, legal aid.